contracts today, we talked about agreements to agree. The biggest takeaway from this is honestly just do best practices. Don't try and work your way around something just to give yourself a bit more time to figure it out. There are obviously occasions where more time is necessary, but if it's possible, you should definitely just draft the contract and get it over with, even though it might be a little frustrating, but always be as clear as possible. That's the biggest takeaway from this. So what is an agreement to agree? Well, an agreement to agree is that you are drafting an agreement saying that you will agree to another agreement later. That's the very basic concept of an agreement to agree. We talked about a couple of cases here. The first was Walker v. Keith. This is about an option to renew a lease, but the issue that we had in this case is that the term, the rent amount, was not well defined. There was no price associated with how much the rent was going to be on in this renewal agreement. And there was no method of obtaining an actual term on this material term. And that was it. But there are some ways that you could get some of those methods, and that is to have a third party say that this is a fair price between the two, and you agree that that is a fair price between the two. You have you've got some kind of formula that determines what the price is going to be. You compare the land to other lands, and you write that specific. Here's the lands that I'm going to compare this to determine what the price, the value of the property is going to be. But the issue in this case is that there wasn't that term there. And the courts are not in the business of actually figuring out the substance of a contract. So the courts can't say what value this term should be. There are some exceptions to this, though. The UCC's Section 2305 really takes into account real-life situations. And there's a lot of situations where people trust one another, and they aren't very clear in their writing, in their contracts. And so this section of the UCC allows contracts to be enforceable, even if there isn't a material term. But once again, this is not ideal. If you can write a term clearly, then you should write the term clearly. Don't skip on it just because you have this provision in the UCC that allows a contract to be enforceable, because that's going off the rails trying to figure out a way around it. Another example of this is Quake Construction Inc. Versus American Airlines Incorporated. And what happened here is that American Airlines employed a company called Jones to figure out all the bids for construction on the new terminal that was growing in the O'Hare Airport. What happened here is they offered a bid to Quake. They offered Quake the opportunity to bid. Quake bid. Quake was given the opportunity to work. They were authorized to work, but they needed to give American Airlines some information about the subcontractors that they were going to use. And Quake was like, well, our subcontractors aren't going to give up their license information unless there's an agreement. So before drafting a formal agreement, Quake said, okay, we will write this letter of intent that should give them reassurance. However, we are reserving the right to withdraw this letter of intent. The day of construction comes around. Quake shows up to the meeting. He's told that he has the job. Everyone's told that he's the general contractor. And then after the meeting, he's told that he's fired. And he sues because it's a breach of contract. And American Airlines argues saying, no, we didn't actually make a contract, and we have this clause that says that we could remove this contract. But you can actually hear the redundancy in that section saying, we didn't make a contract, but we have this cancellation clause to remove this contract. Why would you have a cancellation clause for a contract if it's not a contract? And there isn't. So there's a whole lot of confusion on whether or not this is a contract. and whether or not American Airlines and Jones intended to actually form this contract. And since we don't know this intent, we need to figure out the facts of the case to figure out intent. And this is one of the few parts of contracts law where you're going to see whether or not, where you're going to apply a subjective test to see whether or not there was intent. A good way to put this, to simplify it, so to speak, is to say that enforceability, meaning whether or not the court can say this contract is valid, enforceability is a function of intent. If you can't figure out the intent of the paper that it's written down on, the contract is going to be ambiguous. If the contract is ambiguous, you need to look at the intent of the parties in their minds through other facts and actions that they did to determine whether or not this contract was intended to be binding. What I'm trying to say simply there is if the paper is ambiguous, if you can't figure it out, you need to look at the intent in the minds of the parties who drafted up and agreed to the contract. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.